Hello and welcome to Marbury v. Madison Part 1. This is a very complex case, and so I want to take some time to look over both the facts and the legal argument and get clear on what is the issue in this case. Let's start with a review of jurisdiction, because the jurisdiction is at the heart of Marbury v. Madison. So Article 3 confers two types of jurisdiction on the Supreme Court. The first is called original jurisdiction, and if you remember from our previous lecture, a court with original jurisdiction is basically a trial court. It's the first one to hear a case. The case originates in that court. And so the Supreme Court has original jurisdiction, and in cases in which it does, it functions like a trial court. And here's what Article 3 says. In all cases affecting ambassadors, which is a foreign minister who represents their country in the United States, other public ministers and consuls, so other foreign dignitaries who represent their countries here in the United States for business agreements or other sorts of things, and those in which a state shall be party. So if a state sues another state or sues the United States government, the Supreme Court shall have original jurisdiction. Okay, so that's very specific, and Marshall points this out in his opinion in Marbury v. Madison. Article 3 is very specific about the original jurisdiction of the Supreme Court. It contains only those three categories, and it excludes everything else. So that's important to note, because the original jurisdiction of the Supreme Court is set in stone in Article 3. The second type is appellate jurisdiction. And Article 3 says this about the court's appellate jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as Congress shall make. So that's important, because it notes that everything else other than those three categories falls into the court's appellate jurisdiction, and that last clause has been interpreted to mean that Congress has the authority to set the parameters of the Supreme Court's appellate jurisdiction and even exclude or accept certain things from the Supreme Court's appellate jurisdiction. Just a hint, give you a look behind the curtain. So Marbury versus Madison is all about the court's original jurisdiction. Ex parte McCardle, which is a case we'll get to shortly, is all about the court's appellate jurisdiction. So that's why we're taking those two cases. So to understand this case, we've got to have a little bit of background about the political context, because this is a fact-driven case, okay, and the facts are a bit complex. So Thomas Jefferson wins the election of 1800, and his party, composed of largely of anti-federalists, they were called the Democratic Republican Party, they take over Congress and they boot the Federalists out. So the Federalists have lost the White House, the presidency, the executive, and they've lost Congress. Before Jefferson and the new Democratic Republican Congress take office, the lame duck Congress passes something called the Organic Act. Now, an Organic Act is something that organizes a territory. This Organic Act organized the District of Columbia into the capital of the nation, and it provided for officers for the District of Columbia to govern it, and those officers largely were justices of the peace. And the lame duck Congress confirmed a number of nominees that the lame duck President Adams made to fill those justice of the peace positions, and one of them was a guy named William Marbury. And so his commission was all signed. He had gone through the confirmation process. The president had affixed his signature to his appointment. It had been sealed, and the only thing that didn't happen was that it wasn't delivered. And the reason it wasn't delivered was they just ran out of time. President Adams' term expired before they could get the commissions delivered to William Marbury. Secondly, the lame duck Federalist Congress passed the Circuit Court Act of 1801, which created a whole bunch of circuit judge positions in between the federal district courts and the Supreme Court. And guess who they appointed to those positions? Federalists. So basically what they're trying to do is preserve the Federalist Party by allowing it to take over the court system. Well, when the new Federalist Congress takes office, the first thing they do is they repeal that act. And the problem with repealing that act is that Article 3 judgeships, once you've been appointed to them, they're for life. They have life terms and in good behavior. So it's a real question, a constitutional question, as to whether the Federalist, the Democratic Republican Party, that new Congress, can repeal that act. They're taking away something that the Constitution gives a life interest in. And then you should also know that John Adams appointed a Federalist as Chief Justice, and that Chief Justice's name was John Marshall. Marshall was not his first choice, and he was not even his second choice. He was his fourth. But Marshall is an ardent Federalist, and he is all about national power and preserving national power and interpreting the Constitution to do so. It's also interesting to note that John Marshall was the Secretary of State who did not deliver William Marbury's commission. Then he left office to become Chief Justice and then ruled on the legality of Marbury receiving his commission. At this point, you should note that the Supreme Court is really a non-player. It had no political power. As I've said before, no one really knew what it was supposed to be doing, what its role was going to be. And it was so insignificant that Thomas Jefferson abolishes the 1802 term of the court. The reason was they didn't have enough cases to warrant holding a court term. The final thing you should know is that Thomas Jefferson and John Marshall were cousins, and they hated each other. Marshall was an ardent Federalist. Thomas Jefferson was the head of the party that displaced the Federalists. He became the leader of those who had opposed the ratification of the Constitution. They accepted the ratification of the Constitution and elected themselves a leader that was going to try and interpret the Constitution to limit national power. But they really hated each other. And this is the context in which the court decides this case, and it's important to understand all of this. All right, so the last thing you need to know is, what is a writ of mandamus? Well, it is an order to an officer or official to do his job. So James Madison, Thomas Jefferson's new Secretary of State, was not doing his job. He found that commission to William Marbury lying on his desk when he walked into the State Department. And he looked at it and said, "What's this?" "Well, it's a commission signed and sealed by the president." He burned it in the fireplace of the State Department's offices and refused to do his job by delivering it. And so William Marbury goes to the Supreme Court and asks for this writ of mandamus. Please send this writ to James Madison telling him to do his job. Well, Congress gave the Supreme Court, and only the Supreme Court, no other court, the power to issue these writs. And it did so in our old friend, the Judiciary Act of 1789, specifically Section 13. So the Supreme Court is the only one that can issue these writs. So a writ, an appeal for a writ of mandamus, has to originate in the Supreme Court. Well, that's a problem, because if the Supreme Court issues the writ, it would do so under its original jurisdiction. And as we know, the court's original jurisdiction is set in stone. And we've looked at the language in Article 3 of the Constitution, and we didn't see anywhere where it said writ of mandamus in there issued to an American official. This is a problem. All right, so we will go on to our next section, Marbury v. Madison, Part 2.